good morning, people. It's good to see you guys. Oh my goodness. All right, so let me just cut right to it because it is 9 a.m. right now, and the Zoom that I have doesn't look like it's working, or they're waiting for someone to. We're waiting for the judge to log in, I guess. Let me take a look elsewhere. Hold on a second here. Yeah. Yes, coffee. Thank you for being ready. All right. So I hope what I have is the correct Zoom link. I hope. But in the meantime, we'll wait. And yes, free Turtleboy, absolutely. And pinned to the top of the chat is Turtleboy's Defense Fund. If you all are feeling generous, but as I understand it, this is a motions hearing, and as I understand it, we will be hearing arguments from both Bradel and Betterow today. And I am excited to see Betterow in action for the first time. So hopefully we get to hear it and see it, because this is the Mighty Mark Betterow's big debut. And I'm totally here for it. But anyways, how are you guys? No, seriously, it's really good to see you guys and hang out with you guys first thing in the morning. I woke up and rushed and said hello to Tom, and as a matter of fact, let's drop in on Tom and Mike and see how they're doing. Let's do that. Do exactly that. Because we always do that. We always do that.
What's up? No? Huh?
What's up, bud?
Filled. Yeah. Wow. No, say truth and transparency. Thank you, dear. That was a great thing you did with Flap.
I remember the whole clap thing. The guy would just keep talking and talking. We'll see what happens today, man. Hopefully, Krupp's on time today.
Superino's entered the chat. Yeah.
Yeah. So hopefully, this is Judge Krupp's thingamabob here. Hopefully. What? I don't. What?
Oh, here we go.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat.
How dare you?
What in the heck is going on here? Hold on. Sorry, I meant to. Here we go. Tess, thank you so much. Good morning, Will. Let's go Betterow. I agree, 100%. And Rob Malo, or Mayo, I can't tell if that's an I or an O. Became a YouTube member. Thank you for becoming a YouTube member, buddy. Appreciate it. And thank you, Amy in Boston. And there's my man Scott McGinnis.
Morning, Tim.
There's Mr. Bradle. Tim Bradle,
Yeah.
y'all.
Small courtroom, bud.
Tim Bradle.
Yep. There goes Bradle.
All right. They're all good.
Awesome. Check. Now he's in good hands. Now I'm not
Very
worried
good.
about
The
it.
killer bees are intact. We have both of them here.
Against the friggin'
All right. Fairy Raven, member for 15 months. Thanks for the coverage. You're welcome. And guys, make sure real quick here. Stop whatever it is that you're doing at the moment and click on this link I'm dropping here and give Tom and Mike at Seeking Justice a like, because those guys are heroes. Tom CPU is always out there. Tom CPU is always documenting what's going on outside of that courtroom and providing data and proof via video footage that the mainstream media's their depiction of these beautiful, wonderful people, though all of them heroes who stand outside of these courtrooms every time there's a hearing for Aiden, Turtleboy, and every time that there's a hearing for Karen Reed. And they're always out there. So please stop what you're doing and give it a like. And subscribe to Seeking Justice as well if you're not subscribed to them. Make sure to do that. Because I'm really, man, they're really, really getting really comfortable with what they're doing. And each time they go live, I enjoy it more and more. So I'm definitely a Tom and Mike fan.
He's not even strapped in.
They're taking down the American flag banner and they're putting up the Christmas.
Where's his safety? He's supposed to be strapped in. Like clicked in. No? They don't do that?
I don't know. I think if you're not going over 20 feet, you're okay.
Okay. Good.
I don't.
Is that a crop doing detail over there? Yeah. Right.
Yeah.
All right.
Thank you for
Do they have
subscribing.
a safety harness in those buckets?
Yeah. Yes.
Better fucking believe I'm one of the good guys. But I appreciate you subscribing. Thank you. And yes, if you're not subscribed to this channel already, please make sure to subscribe. It's very helpful. All of you watching on X, just go on YouTube and hit subscribe on here for me. I'd really appreciate it. I think yeah. Thank you, Street Squirrel. I think Aaron's gonna be okay. Aaron started off in a little bit of a mood, but we love you, Aaron. As long as you behave, be nice, okay? So we're all here with good positivity.
Gives Henry too much lead.
Too much leeway, right?
Bad doggy.
If Brian Hill was here, okay, that dog would be absolutely attached to that boy.
All right,
That dog loves Brian in a way I never seen a dog love in anyone. And it's just, they're just friends. But that dog knows Brian, loves Brian, and would just go home with him without a heartbeat. For whatever reason. Nice.
Has anybody seen Cosgrove walk in yet?
Have not seen Cosgrove yet. Anyone seen anyone in a wheelchair? No? Oxygen? Nobody?
Yeah, you won't do.
Yeah, the old guy. No?
They pour him in the back door, Tommy.
Oh, that all right. Never. Yeah. Back door. He's a back door guy.
You look for the bus to pull up and lower him down.
The bus. Are we talking about the bus?
Holy shit!
The bus. I know about the bus.
So don't forget.
When did Cosgrove retire? The 1970s?
I'm gonna retire the bus. The bus is getting retired.
Don't forget about the submarine people.
Speaking of tree services, right?
Right. That's a big truck.
Yeah, and raised the thing when it said free Karen Reed in the back of it, spray painted.
Yeah.
That day was amazing.
That was amazing.
Who was the guy with the truck? Wasn't Kurt.
Oh.
No.
Kurt's got a rack. This guy had
There's a guy. Remember, we're talking about the guy with the dump truck, Mike. He parked right here,
Oh, Keith Landscaping.
and he opened the back. He put the thing up,
Yes.
and then inside it said "Free Karen Reed."
Yeah, it was O'Keefe Landscaping Company.
Yeah, that was
Yep.
That was
Awesome.
man,
Yeah.
awesome. Yeah, everybody felt it.
Yeah.
Yep.
Yeah, Truth and Transparency needs to come on here, man.
Will.
Sometime when you're ready, whatever. Yeah.
It's hard to remember exactly what day it was.
Yeah,
They
no,
all
huh?
kind of mingled.
I don't remember that. I remember the day, but I don't remember what it was.
I think it was before the buffer zone, though.
It was. We had the stairs.
Because we were down here.
Right, we had the stairs.
Yeah, it was one of the
Because
first
I was
couple
up-
weeks. Yeah.
I was up there with Aiden, and Aiden was like at the middle. Yeah.
Yeah.
He pulled off, literally stopped traffic and raised the bed. I remember that. It was awesome.
Yeah.
Probably summertime of 2023.
Yeah.
Yeah, it was. Yep.
And you all witnessed it. That was quite a day. And then if you were here, the crowd just erupted. So yeah.
Oh, really?
Absolutely
The crowd went nuts.
Oh my God, Mike, you could feel it. I mean, the crowd went absolutely insane. Yep.
It's one of the reasons that
The energy.
DA Meatball asked for a 500-foot buffer zone, and
Yeah, because all that.
Bev made it 200 feet.
Yeah.
But
Even that's
no,
unconstitutional.
DA Meatball hated the look. He hated all of us out here.
Yep.
Couldn't stand it.
Yeah, we're all the supporters.
Sorry, guys. We're on. Give me 1 second here. Let me pull it up. So far, it's only audio, but people are shuffling into the courtroom now. So if we can't see it, we'll at least get to hear it.
Just waiting on Tori. She did. Thank you.
Plumber? No. Nice try, though. Yeah, no.
Come out, keep your cell phones put away.
All right, so the bailiff is letting everybody to go. No, listen, there's a bunch of people streaming this today. Make sure to give a like over to the Young Jerks. Make sure to give a like over at Melanie Little. There's a lot of people streaming this today. So, and we're all on the same team here. We all want the same things.
Good morning, Your Honor.
Make
Ms.
sure to
Conley.
support all your creators,
For the
okay?
record, before the court, numbers 1 and
Thank
2
you
on
so
today's
much.
list, Commonwealth versus Aiden Carney, 23 CR 313, 24 CR 43. Mr. Carney is present, along with his attorneys Timothy Bradel and Mark Federow. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for hearing on various motions. If the parties could please identify themselves for the record.
Good morning, Your Honor. Robert Cosgrove for the Commonwealth.
Good morning.
Good morning, Your Honor. Timothy Bradel on behalf of Aiden Carney.
Morning.
Good morning, Mark Federer.
Okay, good morning. First things first, I served with Attorney Cosgrove when he was Judge Cosgrove on this court, and I think this was the only place we overlapped when we were sitting at the same time. I don't think it raises an issue for me, having searched my own conscience. I understand that that fact has been disclosed to defense counsel, and defense counsel doesn't have an issue, but I want to just flag that and make sure that's correct.
That's correct, Your Honor. We're fine.
Okay, and does the DA's office have any problem with my presiding?
No, Your Honor.
Okay, all right, so that out of the way, tell me what you think we have on the agenda for today. We had it scheduled for an evidentiary hearing on suppression. I was hard pressed reading the papers that I could find a reason for an evidentiary hearing.
You're right, Your Honor. And in light of the recent series of concessions or admissions or stipulations, if you will, of the Commonwealth, we're not proceeding with an evidentiary hearing. We're going to be proceeding with documents from the acknowledged record of the case on the unreasonable delay issue, emails, quotations from the record. I just have exhibits that I would be offering as I argue.
Okay. It's not entirely clear to me that I have seen everything. I have a lot of stuff was coming in fast and furious over the weekend, and so I'm not sure I've seen everything. But we'll take it as it comes. Let me just ask in terms of the history of the case, is there now an order for the prosecution of a taint team's review of any kind of electronic data?
No, that's an issue that, I'm sorry, Mr. Bradle. That's an issue that I would hope to raise today.
This guy.
The motion before the court presented by Mr. Bradle to essentially abort that process and return the seized items to the defendant on the grounds that the Commonwealth has unreasonably delayed in following through on the taint team process. So
I just thought I saw something in one of the papers that I reviewed that the issue of a taint team and the procedure that it would follow was submitted to another judge and was considered by, I think, her. I think it was Judge Rayburn. And I don't know if and I think it was even referenced that she took it under advisement. And I didn't want to step on her toes if she had something under advisement with regard to that.
that was my understanding as well, Your Honor, that she took that motion under advisement at the end of the last hearing. That was the last I have heard of it, frankly, and I don't know if she has, in effect, ruled by silence by simply scheduling the hearing on Mr. Bradle's motion to dismiss for unreasonable delay first today, and not acting on the taint team motion, or whether she is still contemplating filing something. I don't know if the clerk has any insight on.
Does anybody have any objection to my contacting Judge Rayburn to find out if she feels like she still has anything under advisement, or if it's still open to this court to reconsider anything or consider anything that she hasn't decided?
None on the Commonwealth's part, although I would ask the court to advise her that in light of some of the filings today, the Commonwealth has filed a superseding suggestion for the taint team process. So much of what she now has, I would say, is probably obsolete.
Because my take on it, I have a pretty good memory of this part of it, is that that on that date, counsel had proffered a motion providing a framework for a taint team. I came in that day and announced to Judge Rayburn that we intended to file a motion to suppress for unreasonable delay, and that I suggested that should take precedence over ruling on the taint team framework. And she agreed with that. And so I don't think she's I don't think we're going to get a ruling. I don't think she has anything under advisement. I think she agreed with me that she was going to hold off on that in light of what we're about to do here today, which is the motion.
Mr. Bradle may well be correct. I would just say that our recollections differ.
All right. just as a matter of courtesy, it would be my inclination to call her and make sure that she doesn't feel like she has anything under advisement. Do you have any objection to that?
No, not.
Okay, so I'll make that call when I get off the bench.
What's up, Broken Baker?
All right, now, is there a logical order to take up the matters that are,
I would suggest, Judge, the motion is suppressed, and then my brother's going to argue the Rule 17, Rule 14 issues, and then I'll take up any other residual issues we need to talk about.
okay, why don't we deal with the motion to any objection to that order?
No, I think
Okay.
that's fine, Your Honor. I have a couple of things I've filed that I would want to address at the conclusion of the defense motion.
Sure. Okay.
As I said, this is going to be a motion where it's on the documentary record. I have exhibits that I've given to counsel that I'm going to proffer to the court as I go, if I may. And we're going to be relying on basically the documents I'm going to be proffering to the court as exhibits. The docket, here and there, I may refer to dates that are in the docket. For example, there's a May discovery deadline that came and went. I'll refer to that. And then stipulations of counsel, where recently in this last group of filings from the Commonwealth, they stipulated and agreed that Mr. Carney's phones were searched,
Right.
which was kept from us till that acknowledgement. So that's a whole other issue that we want to get into. But I would use that as.
It doesn't seem like it was kept for you because at least Mr. Bettero's letter references it. So you had information about it. Maybe it wasn't disclosed in the Rule 14 process, but it was known to you. But in any event, why don't you just, I don't need to wind up, get at it.
Sure, absolutely, Your Honor. So, Your Honor, in this case, I came into this case on 10/19, Your Honor, and I immediately sent an email to Special ADA Mello saying that basically, hold on a second here, these phones have all sorts of privileged materials in them. And so I didn't have an exact clear picture of what was in them at that point, but I knew.
There was no assertion of attorney-client privilege.
Yes, and other privileges too, Your Honor.
No, there was no assertion of attorney-client privilege in October, right?
Initially, I said there was privileged material, knowing that there was source material, journalist source material. The most important thing that I was concerned about right when I came into the case, Your Honor, which was that these phones had source material given to Mr. Carney from confidential sources, some of which were law enforcement people, about the very same investigators that had seized the phones. So that was the primary concern right at the beginning.
Preventive medicine doesn't deal with that, right? Preventive medicine deals with the attorney-client privilege. But in your initial disclosures or your initial representations, you were not representing that there was attorney-client privilege material on the phones.
Right, not on the first day or two when I got the case. I didn't know that yet.
Okay.
But I did say, hold on, there's privileged materials in these phones. And I wasn't certain exactly everything that it was. And my first concern was the source material. And there is a protocol in the court, and I'll give the court the citation. I don't have it right off the top of my head here. It's in my papers, but I'll give you the citation that a court needs to do a preliminary determination when there's journalist source materials raised. And I properly raised it. And I said that you know.
This was prior or it was before or after the issuance of the search warrant?
It was after the issuance of the search warrant.
After issuance of the search warrant. So a judge had previously authorized the seizure and search of the phones, right?
It's a little more complicated than that.
One thing I didn't have is the search warrant and the affidavit in my review of the papers. Maybe it's in here somewhere in some previous filing, but it wasn't attached to any of the papers that I saw. So I need to get that.
All right. Couple of dates. 10/6 is when Judge O'Shea issued the warrant. 10/11 was when they were executed, and 10/13 was the date they were searched and extracted. And we didn't know that specifically until counsel gave us the Celebrate reports, which showed that Trooper Garino searched the phones on 10/13, and I have those, and I'm going to proffer those up as an exhibit. And Judge, the first exhibit I'd offer is my first email to ADA Mello.
All right, do you have a pile of these exhibits? Just give them to me.
I do, sure.
Give me the 10 exhibits that you want to introduce.
Sure. Here you go.
I don't need them leaked out, okay? You got 10 exhibits? How many exhibits you got?
Thank you. It depends how you want to do them. If you want to do, thank you.
Are these in order?
Somewhat, Your Honor. There's emails and there's
All right.
statements.
All right, so let me just see if there's any objection from prosecution to any of these.
None, Your Honor.
Okay, so just for the record, we have an email from Tim Bradel, subject Carney, date October 19 at 3:57 p.m. We have Commonwealth representations regarding searching phones, a single-page document. We have application for search warrant, single-page document which has certain highlights on it. We have a screen share or a, what do you call this?
A screenshot, Your Honor.
Screenshot, thank you. Which in the middle says Windows cannot open the folder.
That may not be, that may not have to come up, Your Honor.
Then I'm sorry?
That may not come up, Your Honor. It's a.
All right, then we have a progress report of an extraction from Trooper Guarino. We have two of them, actually.
Those are 1013, Your Honor.
All right, then we have a copy of, looks like the same email from Tim Bradel. You don't want a duplicate copy, right? All right, that's a duplicate. Then we have a email from Brian Tully to Tim Bradel dated April 27, 2024, which is a multi-page document.
Actually, Your Honor, the stapled copy is a series of emails going through December 20th. This refers to my request for a team and to cease searching, and it lays out the factual back and forth about the Commonwealth's refusal to.
This is April 27?
I have it's a packet that begins with October 19th, and the last page is a December 20th email.
I see, okay.
Yeah.
Yes.
That
We'll
lays
mark
out
these,
additional-
we'll mark these in the order I just identified them.
Sure.
Okay, as one. Looks like 1 through 7.
Thank you, Your Honor. So, Your Honor, at the very beginning of this case, 1019, as soon as I was retained on this case, I asked if they would agree to the appointment of a taint team on 1019. I cited the preventive medicine case in that email. Counsel, if you ask me, clearly didn't apprehend, Counsel Mello clearly didn't apprehend anything about the case law about a taint team. He, on the same day, he said he would not agree to any third-party review. That's the second email. And he said he doesn't know how far they've gotten. And we were going to go to Stoughton Court at the time. I was going to go in there with a protective order to stop any searching and ask for the taint team in light of their refusal to cooperate, even though I cited the case. And a couple quick things about preventive medicine, Your Honor, I know you're aware of it, is it puts an affirmative duty on the Commonwealth to go to Superior Court and put before the Superior Court a protocol to protect any privileged documents. And
Which privilege?
well, that's the question, Judge.
Well, what is preventive medicine deals with attorney-client privilege, right?
Preventive medicine deals with attorney-client privilege.
Okay.
There's other privileges as well. Like I said, I'll give you the case. I just don't have it right in front of me. The case law says that when there's journalist issues, the Superior Court will do a review, a preliminary review of it.
It would be nice to have that case.
Yeah, I'll get it to you, it's in my computer, Judge. I'll get that to you. But just for purposes of my argument right now, I'll just say that was on the table as well. He's a journalist. He has all this sort
All of that was known to the judge who issued the warrant authorizing the search of his records, right?
I don't know, Your Honor. I don't know. I suppose so. You know, these things are,
Thank
What
you.
the fuck
know,
is going on here?
it's the Onyx White language, Your Honor. The cell phone,
The honest what?
the Onyx White case.
Oh, Onyx White.
There's some language out of that applies here. And the language is that.
Why does Bradel know the law
you know,
better than the
a
judge?
cell phone is, you know, the file cabinet of everyone's entire life. And it's akin to, you know, issuing a search warrant for an entire city as opposed to one residence. There needs to be issue, there needs to be a focus on the overbreadth of the warrants here, Judge.
Well, that's a different motion.
Well, I don't think it's a different motion. I think it's another privilege that I wanted to bring before the court. And so that's what I was doing at the time, was saying, hold on a second, we need to deal with this taint team issue. And at some point, it was communicated.
Ella said no.
At some point,
right?
Yes, he said no on the
Okay.
19th.
Okay, and then you filed a motion for protective order or something?
I filed it in Stoughton District Court.
Okay, and what happened on that?
And then Attorney Mello came in and said, well, we're indicting the case anyway, so, and it wasn't heard in Stoughton District
So
Court.
you renewed the protective order in the Superior Court post-indictment?
So in Superior Court, Your Honor, at that point, the chronology is important. In November, Your Honor, that's when Attorney Mello did an about face and said, okay, we're going to stop searching.
Okay.
And Attorney Mello made all sorts of vague, contradictory statements about what the status of the phones was. And those statements are in one of my...
So there's no contest that was abided by, the Commonwealth abided by that representation. That is to say, there was no searching after Mello said we're going to stop searching. The searching that you're talking about that obviously happened back in the October timeframe,
13th,
right?
Correct.
Before you even asked for the taint team.
Right. We had no idea that happened.
Okay.
And it was never disclosed to us. In fact, it was covered up and we were lied to about it.
Okay.
Now
and
we
one of my
get to
exhibits, judges, 6 quotes from the Commonwealth. And just so I'm clear here, Judge, we have no beef with Attorney Cosgrove's veracity on anything. We're talking about, he was brought into this thing later.
Did he say we have no
beef? We're not
beef?
saying that he participated in any cover-ups or misrepresentations. But the first 4 are all blatant lies. If you look at number 1, this is the document marked Commonwealth representations regarding searching phones. That exhibit, Your Honor, indicates number 1 at 11/28/23. Mr. Mello said, the state police and the investigators have not perused the material. It is in pristine form located on the defendant's devices. That is a complete falsehood, and we know it's a falsehood because on 10
I'll go back and listen to the hearing and to take it in context. Okay,
Sure.
I'll look at it.
Go right ahead.
I'll look at it.
All of these are all misrepresentations.
Okay.
So they've misled us as to the state of the evidence. And they not only had the search of 2 of my clients' phones.
How are you prejudiced by that?
How are we
Because
prejudiced?
it's obviously there was
Yeah.
a search. The search happened.
Yep.
You're gonna get the contents of the search, right? The extraction. Where's the prejudice?
The prejudice, Judge. So first of all, this is a suppression for unreasonable delay. My brother's going to talk about discovery issues and prejudice, but in terms of an unreasonable delay, Your Honor, this all goes to the reasonableness of the delay. But to answer your question, I know you always want to answer a judge's question when they ask you a question. And the answer is, the prejudice is that the whole reason the Commonwealth was doing this was to stop Mr. Carney's reporting. That's why they didn't want to give him back anything. They wanted to get in there. Remember at the time, the FBI was investigating these people. They were dying to know what was in Mr. Carney's phone about the FBI investigations of these people. Mr. Carney was eating their lunch in the media, exposing them for all sorts of untoward behavior in the Karen Reed case, and they wanted to stop his reporting. They took his phones under this never before generated theory of witness intimidation. They took all of his devices, they cleaned out his house of every computer, iPad device in there, and they kept it. And it was full of his.
But you're looking for a sanction in a criminal case that would advantage your client, unrelated to what you are described as the prejudice. The prejudice is different. The inability
How is
to
it
report.
unrelated?
And if he was somehow hindered in his ability to report, I would have thought that you would have petitioned for the return of the phone.
That's just part of his
Why
argument.
the phones are so important, I'm not sure I know. Is there an affidavit to that effect before me?
What?
We did petition for that, Your Honor. We asked for the phone.
When was that? Where's the motion? Where will I find a motion for return of phones?
We asked for the.
Is there a motion for the return of the phones?
I don't think we got that far, Your Honor, because We were
Is there, okay, so now the next question, is there an affidavit describing the prejudice that you describe?
Judge, the prejudice is that a journalist has had the tools of his trade taken from him, and every single day he cannot access the tools of his trade. That's the prejudice.
If somebody takes my phone, I go to the Apple store the next day, buy a new phone, and I'm up and running, right? There's no problem with that.
No. He couldn't do that, Your
So
Honor.
that's why I'm asking for an affidavit, okay? And I don't have an affidavit from you, right?
Judge, you know, we
This
have...
judge is a dick.
We have provided so much to the Commonwealth, asking for the phones back. We were under the impression they were not searched yet. You got to remember that we were under the impression they were not searched yet.
Why would he
So there
file
was-
a motion
so we
for it
wanted
if
either a mirror image of the devices or the devices back, because that's what the Commonwealth does in these cases, is they have the ability to give the phones back. There's no issue with the fact that the Commonwealth can take a mirror image of a device
why should he have to file a
and then
motion?
return the devices. In the series of emails, Attorney Mello said, no, we're not returning the devices. We're not giving anything back. And Judge, and also in terms of the items in the phone, Judge, it's not just the journalistic tools of the trade. It's that we needed to use the phones to defend Mr. Carney against these allegations. They're looking for evidence of these supposed instances of witness intimidation. We need to look at them and push back and look at the phones to defend Mr. Carney. I mean, it's not just the journalism issue. It's that this is evidence that we still, to this day,
There you go.
11 and a
Evidence.
half months later, we still don't have. We still don't have
Exculpatory
it.
evidence.
So this motion that I'm before the court on is focused on unreasonable delay.
All right.
Not prejudice, unreasonable delay. And so, but there is prejudice, and I think I answered you that we can't defend Mr. Carney, he can't do his job, and these people are the targets of Mr. Carney's. This goes to the conflict of interest that's been throughout this case all along, Your Honor, is that these are the very investigators that are supposed victims in these 16 indictments in the 23 case, and yet they're still the investigators on the case. And they're targets of Mr. Carney's reporting. Mr. Carney's reporting is in his devices, and they go steal his devices. This thing stinks, Your Honor. So
Get him.
Mello delays the first month into late November of a year ago, Your Honor, saying no.
So let me just focus you on the law for a second, okay? As you know, the Commonwealth submitted an opposition that describes at length
This judge
that
sucks.
the cases that you recite and rely on are not cases where a warrant was authorized for the seizure of the device and search of the device. And here we have that situation. Are you referring me to any cases that deal with the timeliness of a search when authorized by a prior warrant?
I anticipated you would be concerned about that issue, Your Honor. Here's my answer. There are no cases, no appellate cases in Massachusetts. I couldn't find a case across the country where a investigative team had a warrant and then sat on it, didn't disclose anything to the defense for over a year, and was suppressed for unreasonable delay. There's no case where an investigative team did that. I think that's probably a good thing. This is an anomaly that, in this case, the investigative team got a search warrant, searched 2 of the devices, lied about it, kept it from us for almost a year, and then sat on it and didn't share any of the stuff with us, and pretended that they didn't search the devices to us until 9 months ago.
Is there a trial date in this case?
No, Your Honor.
No. Okay. Usually, delayed disclosure is assessed against the prejudice to one party or another, and here we don't even have a trial date yet. So obviously this stuff is going to be disclosed ASAP, right? Whatever was imaged and extracted from the phones in October is going to be disclosed ASAP. And we're going to talk about a schedule for that. Obviously, if there's going to be a search of the other devices, there's going to need to be a taint team at least to evaluate your argument that there is attorney-client privilege material on the phone, on the devices, right? That's going to have to be resolved, and that's going to have to be done on an expedited basis, okay? But I am hard-pressed to understand the basis for your suppression motion.
Judge, let me talk about the unreasonable delay. It's cited in my brother's memorandum, and it's the bedrock principle is that reasonableness is the touchstone of every search. Reasonableness. Unreasonable delay, the case law talks about, all the cases talk about when a phone is seized without a warrant, but the delay in getting the warrant. And that delay is never there's some outlier cases where it's a few months that they allow it. But most of the case law, and it's all cited in my brief, is that it's 2 weeks, 3 weeks, a month. That's it to get the warrant and get the search.
Right, without a judicial approval for grabbing something that belongs to somebody else, seizing it,
right, and
hanging on to it for investigative purposes, you need a judge to say that's okay. And essentially, that's what happened here.
Yes.
Right? A judge said it's okay to seize these devices from Mr. Carney.
Yes.
And then,
but where reasonableness is the touchstone of every search, reasonableness still applies. And reasonableness doesn't allow the Commonwealth, in this case or any other case, to sit on evidence and deprive us of evidence for over a year. How much they searched it, they've obfuscated.
Why is that hard to understand?
At the time, we were under the impression nothing was searched. And then Attorney Bettero's letter of 1017, Your Honor, that you referred to, that's around the time when we first realized, not from the Commonwealth, from a whistleblower from the Stoughton court.
There you go.
Who supplied us with an extraction dated 1013. That's how we learned that the devices were searched.
Right.
Up to that point, even Mr. Cosgrove was in the dark about that these were searched. Mello lied about it. He knew about it 100% because he authorized, according to Tully's testimony, he authorized the extraction to go to the Stoughton court back in October of 23. So there's no question that Mello knew about this. It still didn't disclose it and misrepresented to the court that these phones were not searched. So we were misled as to the fact that they were searched.
All right. I think I understand your argument. I should hear from Mr. Cosgrove on the issue of motion to suppress, and then I'll hear on the 1417 motion.
My last point, Judge, if I may, is that reasonableness doesn't go away. And the fact that they got a warrant and then did nothing for a year, that has to implicate reasonableness, Your Honor. And if you use the warrantless cases as a yardstick, this amount of time, Your Honor, is insanely beyond the pale and was done for an ulterior motive of violating Mr. Carney's civil rights and depriving him of the ability to start defending himself. Thank you, Your Honor.
Okay.
Yes.
Attorney Cosgrove.
100%.
Thank you.
I will be brief, Your Honor, and confine my remarks to just a couple of comments. I don't take from Your Honor's questions to my brother that you necessarily have made any decision about my arguments, but I do take from your questions that you've read my memorandum and understand the essential points that the Commonwealth has sought to make, chief of which is that at least 6 days before Mr. Bradel came into the case, and before he made any request in terms of setting up a taint team, and even then made no mention of attorney-client privilege, the phone had already been searched. It had been downloaded. Lieutenant Tully had looked at it. Attorney Mello has not looked at the extraction report. I have not looked at the extraction report. But certainly in terms of purposes of the law of search and seizure, once the phone extraction is made and once the report was perused, certainly by the time the report was perused by Lieutenant Tully,
you suck.
it had been legally completely searched. So from my point of view, whatever the reasoning was back at the time, whether Attorney Mello didn't quite understand the significance of the Cellbrite report or for whatever reason, I don't understand, frankly, why there would be any purpose at that point to have a taint team after the cat was out of the bag with respect to those items.
You need to shut the fuck up.
Would be a purpose at whatever point Attorney Bradel represented to Attorney Mello that there was privileged attorney-client privilege material. In stopping any further search, we still had, I think it's 4 additional cell phones, the exact number escapes me, that were found in Mr. Kearney's closet, and we still had a laptop computer and some other paraphernalia that had not been searched. Mr. Mello's initial representation to Mr. Kearney that the Commonwealth would cease further search, I think was precisely accurate. I think some of his later statements are fairly susceptible to interpretation. He seemed to go back and forth between saying, we'll cease further search, or the devices have not been searched. And even that statement is true if you're talking about all of the remaining devices other than the 2 cell phones that were searched. I emphasize that there has been no harm to the defendant. He has plenty of time to examine the Cellbrite reports. I have yet to look at them, and I represented in my memorandum that I would not do so until we had a chance to bring the issue before this court. But I have here on a thumb drive both of the Cellbrite reports, and there's no need to set a deadline for the Commonwealth to turn that over, Your Honor, because I'm going to hand it to Mr. Bedrow right now, and I'm pretty confident that he will share those with Mr. Bradel, and they can go through those reports to their heart's content. And if there's any privilege material, whether it's a reporter privilege or attorney-client privilege, although
give the fucking devices
back. Tully did not find any that they want to raise an issue about. They have available to them the usual remedy, which they can back up based on the Cellbrite reports. They can bring it to the attention of the court, and they can move to suppress it as is normally done. And the search of those phones, at least, cannot be said to be subject to undue delay. The only undue delay, it seems to me, and the only prejudice is that after telling Mr.
Unbelievable
Bradel we would not proceed with the exception of responding to the request of the clerk of Stoughton District Court and turning over a couple of pages of the Cellbrite report that were
today, Junior
inquiry. The Commonwealth has made no use of that evidence. Certainly, it would have been helpful to us in a grand jury presentation to have had the contents of that report to present to the grand jury, but no specifics with respect to that report were essentially provided.
How long do you
What
say
the fuck are you
the Commonwealth
talking about?
has to execute a search warrant or to conduct a search on a digital device once a warrant for the seizure and search of that device has been issued? So it's the search warrant was executed on the October 11, something like that, and that authorized the seizure of many devices, 2 of which were searched, many were not. How long does the Commonwealth have to search those other devices or to seek to search those other devices?
Well, there's a couple of aspects to Your Honor's question, and please remind me if I forget to address one of them.
Oh my God, dude.
One thing I should point out is that there were multiple warrants. So one warrant basically covered the cell phones. 2 of those, Your Honor, were the ones that were searched immediately. So there's no timeliness issue with respect to those. The rest of them have not been.
You're lying.
The delay has largely been because of 2 factors. One, because we acceded to Mr. Kearney's request that we set up a taint team. And then there has been, I think, a delay in setting up the taint team. And I say this in explanation, not necessarily an excuse, because it is the Commonwealth's responsibility. And that has further delayed matters. When Mr. Bradel brought
This guy's a fucking
the
liar.
matter to Judge Calladane's attention back in, I think it was July, but it was, I believe, our second appearance before Judge Callahan in the context of complaining of a discovery violation. Judge Callahan set a date for the Commonwealth to file a proposal, and I filed a proposal. And I don't think we can be charged with any delay relative to that point. There is a difference between the 4 remaining cell phones, which are covered under the first warrant, which authorized both search and seizure, and the remaining items that were seized, in that Lieutenant Tully did not apply for authorization to search, merely to seize. So that portion has been executed. There needs to be another warrant filed, which we would propose to do at whatever point the taint team is
If the
approved,
judge
or
can't see that these are stall tactics, I don't
whatever
know.
earlier time Your Honor would suggest to authorize the search. As to how long the Commonwealth has to
it's been over a
accomplish this,
year. What the fuck are you talking about?
this aspect of it, I'm not aware of any case law on the subject. Obviously, our position is that in spite of the delay, there's been no substantial prejudice to the defendant, and we're prepared to go forward on it.
Okay, thank you. With respect to
This judge has to see what
the
this
motion
is.
under Rule 14 and 17,
Judge, before we leave it, may I just respond just briefly to my brother's comments?
2 minutes.
Thank you very much, Your Honor. So, Judge, at a minimum, the fact that they still haven't sought the warrant for the balance of the devices, that does fit exactly under all the case law that I cited, and completely beyond the pale in terms of the delay to seek that warrant to get into those devices.
Right.
That, there should be no question whatsoever that those are suppressed as a matter of law, where they didn't seek a warrant to get into those devices and were over the...
Do you have a case to that effect where the warrant is authorized for the seizure of the devices, but a second warrant is envisioned for the search of the devices, and that is delayed? Do you have a case to that effect?
I argue by analogy all the cases.
But by analogy is different. The analogy is to cases where there was never a warrant for the seizure of the device, and therefore the person is deprived of the use of that item without the any kind of a court determining that that's what should happen. But
I would argue it's the same thing, Judge.
All right, I understand the argument
Yeah.
if it's only by analogy.
And-
Okay.
And the 12-month time period, if you look at the judges, is extremely well past all the case law on it. And the last thing I want to tell the court judge is that I found the citation on the journalist privilege. I'm just emailing Madam Clerk with a CC to counsel.
What is it?
It's,
I lost sound there, guys. I don't know what's going on. Here we
the
go.
name of the case is Petition for Promulgation of Rules Regarding the Protection of Confidential News Sources and Other Unpublished Information. 395 Mass 164 at 171, 1985, holding that a judge must balance the public interest in the use of every person's evidence against the public interest in protecting the free flow of information, and indicates that before ordering a reporter to divulge source and information gathered, a judge must first, quote, consider the effect of compelled disclosure on values underlying the First Amendment and Article 16. So that's what I would cite in support of the idea that it's not just preventive medicine. There are all sorts of protections in the law. Journalist material, there's likely husband, wife, disqualified.
Okay, all right, I understand.
All kinds of material in it.
Okay, thank you.
If I may, Your Honor, just on that last point,
All right.
and I don't mean to try Your Honor's patience. I would just say there's a whole line of cases protecting documents, physical documents, when the Commonwealth is contemplating, say, a search of an attorney's office or has reason to believe that there's going to be attorney-client privilege implicated. And that's where the taint team idea comes in. It's not a novel thing with respect to searches of electronic devices, although preventative medicine is the case that applies that to electronic devices in Massachusetts. But normally when the police go in to search a home, there may be all kinds of theoretically privileged material, doctor patients, you could go through the whole list. But normally what happens is the police go through that material in search of whatever they're in search of, and that when we come around to the court, if the defendant has a privilege that he feels would bar the introduction of that material, he brings it to the attention of the court. But there's no procedure that I'm aware of where you screen for every conceivable privilege in the world.
Okay. With respect to the Rule 14, Rule 17, Mr. Betterow?
Thank you, Your Honor. Your Honor, we recognize that this is an uncommon task to ask to seek to review the email of the elected district attorney. But this is an uncommon situation, and it's a situation that the district attorney himself created entirely.
And it was created by an email that he sent or a communication that he sent to the district court chief justice and others about a potential leak of information from the Stoughton District Court.
On his private email.
Okay.
There is also evidence.
Let's assume it was his office email. The analysis wouldn't be any different, right?
The analysis wouldn't be any different,
okay.
But we would have no reason to suspect that this was occurring. And in the context of seeking a Rule 17 subpoena and what is considered phishing and not, it is not an everyday situation where somebody just starts demanding the email of the district attorney because maybe he did something. What I'm suggesting to the court is on that one example, on his private email, which we believe could lead to the inference that that is designed to subvert public records laws, that he sent that, and most importantly, that email directly talks about Mr. Carney in the context of alleged witness intimidation, communications from witnesses who are going to testify against him, and an email which also included text messages from Jennifer McCabe, who is a key witness against Mr. Carney. Additionally, since this motion has been filed, We even learned just last week from the Karen Reed hearing that Mr. Morrissey uses his cell phone to communicate directly with witnesses in the case against Mr. Carney, and those materials are going to be provided to Ms. Reed's attorney. But we also learned that as it relates to Mr. Morrissey's use of his cell phone, that he set his phone, his iPhone, and our subpoena would be to Apple, he set his iPhone to a setting to auto-delete all of his messages every 30 days, which I would suggest to this court is further evidence, possibly, of an intent to deprive what ought to be discoverable, whether it be in Rule 14, which we'll get to, or in getting access to relevant communications from his private server. When you factor in together, and this is an important backdrop before I get into the factors.
Do you think his server maintains the content of his communications that he auto-deletes?
I'm sorry?
You think his server maintains copies of the content of his communications that he auto-deletes?
I believe that Apple has the ability, absolutely, to maintain deleted messages.
Do I have an affidavit or anything else from you to that effect?
No, you don't, Your Honor, but I would...
Do I have any factual submission that we'll find anything in the content of an Apple subpoena that we couldn't otherwise get from Mr. Morrissey?
Well, I'm going to get to that when I get to the Rule 14, certainly as an alternative argument. But to answer Your Honor's first question, every day in this court and across the country, when you hear about so-called Celebrite extraction reports, deleted messages, of course, appear. They do remain on an Apple server. Just because the user may delete them from their device, I would suggest to the court and anyone else that those messages we've all seen can be pulled back and just don't simply delete.
You want me to take judicial notice of that?
I'm not necessarily asking you to literally take judicial notice, other than I would suggest that is a very common thing, and one should not assume that just because a user deletes an Apple message from their phone, that it is somehow lost forever. The purpose of me mentioning to Your Honor the text messages at all leads to why we want Apple to capture the universe of the email communications that we request from Mr. Morrissey. The fact that he does have it set up to auto-delete, the fact that he does use private email to access business, doesn't give us confidence, respectfully, that things are going to be preserved for public records or for disclosure to defendants. Additionally,
dirty.
We now know that the use of the iCloud email by Mr. Morrissey to conduct business is not a one-off. It is not simply the one message that ended up in the hands of Mr. Carney's defense by way of a third party. And I will address this, as I'm sure Your Honor will have questions about a public records request and a response to that as being relevant to whether information is procurable from another source. But it's simply important for the court to know that we now have irrefutable proof by somebody who did a public record search, I have learned, and received some degree of a response from the district attorney's office, that Mr. Morrissey has been conducting business on his personal iCloud account since at least 2020. And the last email that was turned over as part of that public access request just happens to be the September 2023 email regarding Mr. Carney, along with one response from, I believe, the chief judge saying you need to raise this with the Stoughton District Court. It is in that backdrop, Your Honor, that we require a Rule 17 subpoena for this iCloud account, because there is just no reasonable basis to believe that all of the information will be maintained and will not disappear based upon his use of the private server and his auto-delete of the text messages. As far as the relevance under Rule 17, it shows, again, his direct contact with witnesses and with officials regarding things that directly relate to Mr. Carney and his alleged witness intimidation. Notably, the email in question was sent on September 28, 2023. There are documents that are exhibits in the letter that I wrote on October 17th, which I know Your Honor has read, that indicate that Mr. Morrissey had already recused himself officially from all matters involving Mr. Carney by the 26th of September at the absolute latest. This information, if there are other messages, would be relevant to show his personal interest in seeing Mr. Carney prosecuted after he had been recused, the bias of his office, and as Mr. Bradel referenced earlier, the bias of the very witnesses in this case, both police and civilians. Additionally, as Your Honor has taken the suppression undue delay motion under advisement, accompanying the email that was disclosed by the clerk of the Stoughton court to a former clerk of that court included pages of the extraction report that we now know existed as early as October 11th, 2023, which was only disclosed to the defense on December 2nd, 2024. There could be relevant information contained therein that could very well shed light on whether any shenanigans, as Mr. Bradel has alleged, occurred in why cell phones that were searched, at least two, as the Commonwealth now concedes, at no time were ever disclosed, and indeed representations were made again and again and again, suggesting they were pristine and unsearched. As far as not otherwise being procurable in a reasonable manner, the obvious response to that would be, well, if there's a public records request that was satisfied, then, you know, you go through that process, and isn't that another way? And in these circumstances, for some of the reasons I said earlier, we don't believe so. Number one, the person who answered the public records request is literally an assistant district attorney who is literally a subordinate of Mr. Morrissey and reviewing their boss's email. Now, if something were to come...
It's no different than any other Rule 14, right? I mean, the office has an obligation to turn over any discovery materials, right, in the office.
Yes.
An assistant DA reviews the files. That includes the DA's files and anybody else who's, part of the prosecution.
No,
team. It
dude,
happens
not
day
the
in
same
and day
thing.
out, day in and day out.
Not the same thing.
Your Honor, respectfully, what does not happen day in and day out is the elected official district attorney who has been recused from a case is talking about the very case, talking to the witnesses, talking to the detectives. That is absolutely not normal.
Completely unethical.
And in the normal review of discovery, which we'll get to in a minute with Rule 14, I don't believe it is normal for somebody to say, let me look at the district attorney's email. There would be no reason to even suspect that, let alone his private email and private text messages. This is, as I said earlier, Your Honor,
this is dirty.
Not a common case or situation at all. Now, having reviewed the response to the Freedom of Information request, it is clear that there are materials that were withheld. Now, I suppose we could go...
What Freedom of Information request? You made one?
I did not make...
Who made the Freedom of Information?
I don't know who literally made it, but it has come into...
What is it that you're talking about that you're reviewing or that the court should consider with respect to freedom? Who made the Freedom of Information request?
I don't know who made it, but it is certainly...
What did it ask for?
It asked for Mr. Morrissey's email.
So you must have the written letter that was the request.
I do, sir.
Who was it signed by?
It is signed by Brandon Hunt, Assistant District Attorney.
Okay, so the Brandon Hunt, the ADA, made a public records request.
Signed the form. I misunderstood Your Honor's question. It's an anonymous person with an email, a Gmail account.
An anonymous person made a public records request.
Yes.
Okay, and that was responded to by an ADA.
Yes.
Okay, have you made a public records request?
No.
Okay, why not? You're relying on an anonymous email public records request?
Judge, I'm relying upon the response of an Assistant District Attorney who has responded to that and supplied...
Have you seen the request?
Have I seen the actual request?
Yeah.
I have not,
Okay, so how do you know what was asked for?
because they supplied emails, Your Honor, 200 and something pages from 2020 to 2023. The reason why we could make that request, it's going to be the same response. We have to review those materials. They're withholding materials as is indicated in the letter. We could appeal that determination. That could lead to somewhere else. That could lead to litigation. And I would suggest to this court that it is not reasonably a reasonable opportunity without the risk of delaying this for months and months and months.
What's unusual is somebody coming into court here relying on an anonymous public records request made by somebody we don't know, requesting God knows what. You're coming in here as an officer of the court saying, I should rely on that, and I should rely on the response. That is very unusual.
Well, that may be, Your Honor. What
It
I'm
is
simply
unusual.
saying is I'm not asking you to rely on anything other than, and then I believe these emails have been actually supplied in another case. So the prosecution obviously is vouching for the records that were disclosed. They've been turned over, my understanding, under a protective order in another case. I don't think Mr. Cosgrove is going to dispute that. It is signed by an assistant district attorney. What I'm suggesting is to go through this process when the person who is determining what that evidence will be is the elected official subordinate combing through his email, that we lack confidence in that, Your Honor.
All right. It seems to me that this can be handled as a Rule 14 request, no different than any other Rule 14 request to a prosecutor.
If it prefers the court, I will certainly jump to the Rule 14 components of this.
And what is it that you would be making the request for under Rule 14, and why should I consider it before you've made the request? I mean, a Rule 14 is a discovery request. You say, we want X, Y, or Z. Have you made a Rule 14 request?
Many, Your
Honor. And where will I find those? And do we have a motion to compel the Commonwealth to produce certain discovery that was requested under Rule 14?
Oh my
Judge,
God.
they are referenced in the letters that were sent to Mr. Cosgrove, to which we have received in his response papers some degree of a response, and that he agrees to provide us with text messages.
Okay.
So I believe, certainly Mr. Cosgrove is aware of our demand.
But I am not. You're asking me to compel Rule 14 discovery, and I don't have the requests submitted to me.
They were made in August of 2024, Your Honor.
That was a follow-up.
So
It was a May discovery.
all right, but I don't have those. We're going to go back to those discovery motions and revisit those now? You prepared to argue those now? I mean, I'm prepared to have you talk about discovery issues, see if you can resolve them, and if there's anything that the court needs to resolve with respect to emails from the district attorney or any subordinate of his, or other kinds of discovery that there's a dispute about, I'm happy to hear you. But it seems to me in the first instance, you folks ought to talk about it and see if you can resolve it.
Oh my
Does
God.
That does make sense.
Okay. All right. Are there any other motions that I need to deal with?
Not from the defense, Your Honor.
Okay.
Dude, the judge just shut everyone down.
Let me just see for a second.
Yeah, this is what's going on. Exactly, Edward Kirkpatrick. Exactly. Like, why is there a different judge on this case every single fucking time they walk?
What is the status of the request for the taint team, and how that would proceed with respect to the other devices if the motion to suppress is denied?
Your Honor, counsel filed the
This is the dirtiest shit
proposal
I've ever seen.
the last couple of days. We haven't had a chance to go over it or address it. And we would just object to any, the record on that point. We object to any further searches. We object to, the idea of providing us with this stuff here in open court on December 2nd.
All right, here's what I'm going to do. I'm going to see you before Christmas, and you folks are going to talk about the protocols, how it will work. I'm going to get you a decision on the motion to suppress.
Will
And
you
if
be the
there's,
same judge?
going to be further searches, we're going to have to deal with that at a hearing before Christmas so that the case is moving along. You have now the disclosures of the contents of the extraction. And I can hear you on a motion if you're ready for that, okay, on things that you feel like should be suppressed. But I think that's pretty quick for you to pull that kind of thing together. But at a minimum, you folks ought to be in a position to figure out a taint team protocol for review of other devices if they're going to be searched. And you should also discuss any outstanding discovery disputes that I need to deal with. Let's talk about a time when you folks can be back.
Yeah, like I get that, Gonzo, but
I'm happy to do that, Your Honor. There is another motion.
there's
that
a
I
different
filed
judge
that I'd
every
like to
hearing.
see heard on the
Sure.
sidebar.
Who doesn't know what's going on?
Suggesting that we have a hearing across the street in Denver District Court on Tuesday the 17th.
What time is that?
That's a 2 o'clock hearing. Judge, I'm here in this building at 9 o'clock for a motion to suppress with Judge Canoni. Could we maybe suggest, I'm trying to do my best. I have court every single day up until Christmas, until I leave for Christmas holiday. But perhaps if I suggest December 17th, we're all sort of in the neighborhood, maybe an 11 o'clock call here. That be all right?
How about 3:30?
That's fine. That's fine with me.
Okay.
Just give me a moment, Your Honor.
Yeah, sure.
That's a new one. 3:30 in the
So
afternoon.
you know, I'm here at 9, motion to suppress across the street at 2 for Rule 17 and District.
All right.
Right.
And lunch down the street.
December 17th is fine, Your Honor.
Okay, yes, 3:30. We have a long list, I know, on the 17th, and I'm supposed to impanel a jury in the morning. So I don't expect to be able to fit you in the morning. We're clear in the afternoon? Oh, perfect. Okay, so let's say 3 o'clock. So you can finish your 2 o'clock and come across the street, and we'll deal with this. I don't expect it's going to be a long hearing because I think most of these things are going to work out. But all right.
Thank you.
Okay.
Dude, what in the fuck is going on?
Okay. There's another matter that you wanted to address at the sidebar. Attorney
Yes,
Cosgrove?
and again, if I could just have a moment.
Sure.
Thank you, Heike. Yeah, like what in the fuck is going on here? It's been a year. Dude, they gave Brian Walsh's phones back. Proctor gave Brian Walsh's phones back, who is accused of murdering his wife. They gave him back his phones, his devices in 24 hours. 24 fucking hours, dude. I mean, I guess they got us on hold. This is the most insane shit I've ever seen, dude. Dude, like, and Betterow was on fire. Like, Bradel got a little caught off guard. Like, he took the brunt of it at first because he was a little caught off guard at how fucking argumentative this judge was. But as he got agitated, he started, kicking ass. But this dude was immovable. And then Bradel gets up there and kicks ass, but it was like Superman versus Doomsday. Like, it was insane. What's going on here? I mean, we're still on. Like, is it over? mean, I know they were trying to decide on the next date. I think they decided December 17th at 3:30. Right. This guy seems to have just been deflecting everything, just being argumentative to be argumentative, to try to shut down every single thing and find some technicality to shut down the defense's argument here. Oh, it's a sidebar? Thank you so much. Sidebar. Joe Flip Ahead. Y'all need to make sure to sub up to Joe Flip Ahead. Gonzo, totally. And make sure, guys, to sub up to the LV Cops. I think it's the last thing that yeah, there we go. I just dropped their link in the chat. Make sure to sub up to LV Cops. They're the new cop daddies on YouTube. Judge Flatline. But yeah, this is that's the whole thing. So for those of you who are like just catching on to all of this, which I can't imagine you, unless you've been living in a cave for over a year now. And I believe it goes back to October. Since October, this prosecution has been playing keep away with Aiden's devices and with delays in the searches. And there's always a different judge. How in the fuck is that? Like, we can't get a different judge on Karen Reed's case now? I mean, I don't know the law, so it probably is apples and oranges, and I don't know what I'm talking about, but it's weird to me that there's a different judge on this case every single hearing, and the judge always doesn't know what the hell is going on. The judge is always in the dark. And so what inevitably happens is, okay, I'm going to look at this and I'm going to look at this and we're going to set a new date. And we're a year and 3 months into this. Two months. But this is insane, dude. Dude, if I could, I would be going to Massachusetts to these hearings as much as I possibly could. Like, this is insane. What's up, Kelly Reed? Nobody ever seems to want the truth. Right. Right. I mean, this is what you guys have to keep in mind here. This is something that I'm always going to argue this point. I'm always going to make this point. What Turtleboy and what Karen Reed and their camps and families are doing right now, they are relying on a system. This is a fact, people. Relying on a system that is literally trying to railroad each of them. Think about that. Imagine how difficult that can be in theory if you just take a little time and think about that. That is... And these are dirty people. These are criminals who are so faithful in our justice system that they rely on the very justice system that's being weaponized by corruption to railroad them. I have never seen this in my life. Marcy, thank you so much. Appears grumpy is part of the problem. Yeah, this judge, I mean, I don't know. But he was awfully combative. And if we're sitting here wondering why, if we're sitting here trying to figure out what judges are on that list of emails from Morrissey's burner devices or burner accounts, then why in the fuck would I not side-eye this judge? Now, I'm not saying that I don't have any proof of that, but dude, what is this? Like, this is the most this is the I can't even believe this is real life. Yeah, why is the judge telling the defense to go get a FOIA, a records request, when it should be discovery? Now, again, I'm not a lawyer and I don't know what the fuck I'm talking about, but in theory, it doesn't make sense to me. To me, that's discovery. They're entitled to it because it could contain exculpatory evidence. And so therefore, it should be in discovery. Why do they have to file a records request for discovery? That makes no sense. I thought of that too, actually. I'm going to hell. I mean, you have to go back because all of this shit is noise and legal red tape, right? When the truth of the matter, the raw truth of the matter is that Turtleboy was falsely charged, and a law that is completely and totally unconstitutional was weaponized in order to charge Turtleboy because he was trying to prove corruption in the Karen Reed case. He was charged by the very people that the very people that he was accusing of being corrupt. And this has been going on for a year. And we're supposed to not think that this is corrupt. Okay. And I mean, and unless you've been living in a cave again, and you've been following the Karen Reed case, and you see the way that they have been handling that case, and you know all of the details in that, then you know that Turtleboy was clearly locked up or charged because he was onto something. And they can prove, it's just that this judge is not allowing them to get to that point, but they can prove, Turtleboy's defense can prove that he was set up by Lindsay Gattani, the fake victim, Ken Mello, and Brian Tully, that they colluded to set him up so his bail would be revoked and he would be locked up for 60 days. That fucking happened? Brad Blankenship, thank you so much. They are doing everything in their power to delay this until after the Karen Reed case. You can't convince me otherwise. I agree. Well, Mello, this is the thing is Turtleboy and his defense team plan on calling Mello to the stand because they feel that they can prove this.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
Dare you? with his pink cell phone case. I love it. Thank you so much, Cynthia 1880. Well, yeah, they're all working together. I mean, dude, here's a list of people that they feel that they could prove are working to railroad Turtleboy. You have Ken Mello, you have Brian Tully, you have Trooper Guarino, you have Jen McCabe, and you have Michael Morrissey. And that's just the 5 that I could think of off the top of my head. Oh my God, I'm a baffled, gifted 5 memberships. Thank goodness. You are amazing. Appreciate you. That's a long sidebar. What's up, Tammy Holcomb? Tammy Holcomb is awesome, dude. Like every live stream I do, she's always the first one to leave a comment in the comment section after I end it and says, "Great live. Have a good night." Like every time. It's so sweet. It's so nice. All right. We're back.
I just wanted, before we start, Your Honor, I remembered that you referenced a need to see the search warrant affidavit. I filed a copy of the warrant pursuant to the cell phones when I filed my original proposal
fire
for
trucks,
a taint team. I have an additional copy here that I'd
Great,
be
thank you.
happy to hand up to the court.
All right.
Thank you, Your Honor.
You want to see what was just handed up?
We're fine, Judge. We
Okay.
understand.
Okay, very good.
Holly Mack.
Anything else from the
Thank you so
defense?
much.
No, Your Honor.
Okay, we'll see you December 17 at 3 p.m.
3 p.m.
And I do hope that you're able to work out most of the discovery disputes and taint team protocol. Thanks.
All right.
To put it in my file. All right, so that's it. Yeah, I'm dumbfounded at what I just heard. I'm blown away. So let's check in with Tom, because Aiden and Bradel and Betterow will come outside down the court's steps, and they will and Tom and Boston Mike are always there for that. So Tom's always boots on the ground. So I'm going to drop the link in chat. Make sure you guys go over there and give it a like. Please stop what you're doing right now and give Tom and Boston Mike a like. All right. They got me pulled up. If you're going to get an echo, guys, you might want to drop my shit. I just got word that Matthew Farwell's hearing is canceled for tomorrow in regards to.
Yeah, I muted you guys for the ambulance that came by.
So if you guys were looking, if you guys were planning on watching the Matthew Farwell case and following that, in regards to the Sandra Birchmore case, that's been canceled.
That would be something, I'm sure. So. Here we go. Was it as biased inside as it was outside? Yeah, that bad?
Oh man,
not as bad as Beverly. All right.
I would have been fired up inside that courtroom.
Yeah. Brutal. Yeah, you don't.
Hello, hate corruption.
Oh, comment. How is it inside? Good, bad? Same thing? Just unreal, huh?
I guess all the judges are afraid they're going to be on the emails.
Well, yeah, what if this guy's on the emails? Then what?
What's more in the tank for the prosecution than Bevins?
Then really, that bad. We outside it was bad. We heard out here it was not good.
Yeah, no matter what Tronsgrove said, he just let it fly, he nodded and agreement. And sidebar too, they were talking about Katana, you could hear bits and pieces.
Okay.
And he was doing the same thing.
Really?
Brano, just listening to Tronsgrove.
Wow.
I mean, I was a little shocked because I feel like I assumed Bradel filed a motion I assumed it, but I'm not a lawyer. I don't fucking know how these things work.
Another ambulance. You freaking kidding me?
But if Bradle had filed a motion for it, I would have went over it. Hannah, thank you so much. Frustrating. What I'm confused about is why defense is sending docs last minute this weekend. It gave this judge an excuse to say I didn't see it. Yeah, I don't know. I don't know. I have no idea. But thank you. I appreciate it.
The nursing home up the street? Yeah, she lived there.
I mean, I am dying to hear what Bradle and Betterow have to say here. I'm dying to hear what Turtleboy says here. Because you know Turtleboy's fired up. You know Aiden's pissed right now. I hate that good people are going through this like this, man. This is so fucked up.
All right, guys. Questions real quick. Any questions for Bradle or Bedrow? Or Aiden for that matter? Question. Okay. I get that question. All right, does it sound better?
Actually, yeah.
I know, but they're saying I'm breaking up. If that I'm on the stairs, it might be the building.
No,
I may have to come down.
It's just your sound, Tom. It's StreamYard. You've
Does it sound better down here?
Gotta stop using StreamYard when you're out there.
Anybody sound better?
StreamYard sound is terrible.
Okay.
Because unfortunately, what'll happen is when Bradle is
sounded
talking,
really corrupt out here. I don't know how it was in there, but
I don't know, like,
yeah, it's gonna be it's gonna break up a lot. But it's just how StreamYard is. Hannah, thank you so much. Judge saying come to an agreement about taint team without court. Laughable. There's a better chance the Taliban become a democracy than this corruption put DA office cooperating with Turtleboy. Thank you, Hannah A. Right. I mean, a trial hasn't started yet. So I wonder if that even applies. Is there a law? Is there something in this in the Bill of Rights that guarantees you a speedy pretrial?
oh my God. They must be golf, but.
And it's possible
they
he
gotta
waived
go off
it.
together,
Yeah.
right?
It's possible he waived it.
Yeah.
So when you, I checked out find,
That type of corruption. Cops.
yeah, when you're going after the system.
Oh, yeah.
they all-
You think Judge Corrupt golfs with DA Morrissey? Of course he does.
Right. What's his, you know his name?
Scott McGinnis always jumps right to like the worst. I love him.
Judge Corrupt.
So I call him
KRUPP.
It's
Scott McGinnis is always just like, "Yup, that's it. They're corrupt. They're colluding." I love Scott McGinnis so much. Hey, corruption. Thank you. Missed you guys. Member for a month. Appreciate you.
It was like, it's a second.
That's like, well, what do you expect from, Judge Corrupt? Oh my God, dude.
That better? That's about all I can do for the sound, guys.
Yeah, I mean,
That's
listen.
Tim's here again. There it is. Can cable.
How are you?
I'm better, guys. Anything? If you're watching me on a wireless, sometimes your wireless
I don't
is
know who
kind
that
of the
was. I
issue.
thought Tim Bradle was coming down, so he got an applause. Good for that guy. No, Scott is awesome. He's amazing. Scott's out there every.
Wow. No, that's okay. I need to know. If I don't know, I can't try and fix it, right?
Yeah, I think so. Feels like a good idea.
Colder over here by a lot. The wind.
Bev has to move 12/2 to April.
Yes, he does.
Yeah, I'm thinking January may not be good. Do they? Gotta get them. I got a heated vest on right now. I love
Go fuck yourself, Bobby Chambers.
it. Oh, it's so cold. Can somebody kick Mike up? Kick Mike on the Mike up here. Can someone put him up on stage?
JD, it's not that simple.
Oh, there he is.
Yeah, it's not that simple, JD. I can't just DM Tom and be like, here's how you fix your sound. Like, he has to learn how to use a whole nother program, a whole nother streaming software. StreamYard is very convenient and very easy to use. And that's why most YouTube creators use it, including myself. This way you can have panelists on and guests on. It's a lot easier to do it that way. But then there's OBS, which is just, it's like Chinese math to me, dude. Yeah. But it's funny. I just forgot how to use it. I used it before I used StreamYard, and now I just can't remember. I can't seem to educate myself on it. Again, it's weird.
Mikey, I can hear you.
All right.
Can you hear me?
Yeah, I got you.
Oh, there we go. Oh, who's in the tie? Who's this coming out? It might be Bedro.
The judge was saucy, dude. He was spicy.
Yeah, he wasn't happy today, was he?
No. Monday morning, no, he wasn't happy. Hey, Farwell's case got canceled.
Really?
Yep.
Farwell's case got canceled.
Yep.
You think maybe he may be talking?
Yeah, so it's scheduled for February.
Thank you, Go Georgia.
Yeah, something's going on, dude. Something's going on.
Yeah, I agree with you, Mike.
Yeah. I tagged you in the tweet.
Okay, cool.
Yeah.
Robin G gifted 5 members.
My fingers aren't usable for another hour at least to get a defrost.
Yeah.
Yeah.
Cold. I just got back. It's cold out, man. Oof.
Well, we're in the shade and the wind's blowing.
Oh, the wind picked up?
If the wind's blowing, that's what's happening to his sound. That's exactly what's happening to his sound.
Please pass the pepper. Thanks for the $2.
Peppa, thank you very much. Wow.
Commonwealth never ceases to disappoint. Yeah,
Please
right.
pass the Peppa. She's awesome.
So this is it's due back.
Very well. He got the surgery. Good. Brutus. Yeah.
So
Brutus, talking about Brutus, making sure he's all right.
Tommy.
Yeah, we want Brutus to be good.
Tommy.
It feels weird being on the stairs.
I know, huh?
Tommy.
You're on the stairs.
Yeah, there's no tape, Mike. We were like on the stairs. We're allowed to be on the stairs today.
Hey, December 17th at 3:30 is the next motion.
Thank you,
That's
Hey.
Friday.
December 17th at 3:30. Be warmer out that day, Scott.
Anna, thank you so much. Voters should be pissed that GA is wasting prosecution journalists on bogus charges, not going
Good
after
hearing stuff
actual
coming up.
criminals. I
I
agree.
know.
Thank
So
you,
I gotta
Hannah.
put that. Make sure we put that in the schedule. Yeah.
Susie's
3:30.
got the Susie. Get that to Susie. She
All right.
keeps the master schedule we got there.
So that's Tuesday. Okay.
Thank you, Dana. Appreciate you. Make sure to subscribe to Resistant to Silence.
All right. I got it. Tuesday. So
Dana and Tracy. Dana Leonard and Tracy Murray.
Like that one over there.
Over there? Huh.
And Farwell's
I don't know.
date got moved to February 4th, 2025, the 4-year anniversary of when Stephen
Doesn't he
Birchmore's
have,
body was
I already
found.
have a court date that day? Anybody?
what day?
The same day. I think he's got court over there.
Yeah. Everything should be like clear.
I think.
I'm looking at my calendar. I don't see it. I can be wrong, but
Nice. Brutus is good. Me and
all right, cool.
me and Etsy were talking about him, making sure he was all right.
All right. Thanks for the 2
We're worried about him.
Yeah, Pastor Pepper. Thank you.
Everybody prayed for Brutus. That's good.
And everybody that's watching from the glare, welcome. Come on over, buddy. Glare did a good job.
Yeah.
Thank you.
I know Will was streaming us. I know Melanie was streaming us.
Yeah, they're back with us now. They did the phone call inside. And,
Yeah.
that was interesting. I mean, not Mello, but Benro and Bradle were going off, dude. They were like,
Oh, yeah.
The judge was just throwing curveballs.
Yeah.
You know, like little
Yeah,
bullshit
exactly.
stuff. Like, what the fuck? Like,
And-
they're doing everything they can to bury this thing.
Right.
I didn't hear Cosgrove making any arguments at all.
No,
baby
it's
boy.
crazy. Like, and they keep on switching judges, so it's like, not one judge knows something, and another judge goes, "Did you file that?" And I didn't
Did you
get a motion.
file a FOIA? The judge says. Did you file a FOIA? Look,
What?
really, guy?
Fuck.
Really? Like, who's it from? Well, someone else filed it, but your ADA responded to it. So what the fuck? Who cares?
Right. It's
Right?
discovery at that
Yeah.
Even though somebody anonymous filed it, it doesn't matter.
Yep.
Your ADA responded to it.
It's discoverable at that point.
Doesn't make any sense. Yes. The judge was making, I mean, like, he was babbling in there.
Yeah, I agree with that. Anti-Debs crowd walk off subject.
All corrupt
That's
control.
some
You're right.
Lindsay's in there now?
It's like
Right.
right in
that
front of our-
pardon
right in
from
front of
Joe
our eyes.
Biden
You see it happen.
was
What?
son
Lindsay's
is
in
some
Morrissey's office.
hierarchy
You know Trump's
bullshit.
in those emails. You know he's in those emails. Is that SD?
See this? Ah,
Who's that? Who's that?
That was Esty.
No, who's walking out of the courtroom on the other side there?
big victim.
What?
Yep.
Wow.
Oh my god.
Big
With an
victim.
escort. With an escort. Again.
Fake
She's got a court
victims
officer
there.
with her?
Sure does.
Oh,
Fake victims at the
Jesus
courthouse.
Christ.
Ew.
Right, Shirley? What the? And what? Come on. Good job, Tony.
Did you test yourself?
negative.
I don't know, but she got to, she probably get walked to her car, don't you think?
I know.
Unbelievable.
Right?
I mean, that doesn't make any sense.
You suck.
That's wrong. That's just not right.
Yeah, what the
Yeah.
fuck is that
Yeah,
shit?
why is she-
Unbelievable.
Why is she even there, dude?
Why is she there?
Why is she there?
Yeah,
Well, Morrissey obviously told her.
because she's on that. She's
She's
in
so
those emails,
fucking
man.
scared of him, right? She's so fucking scared of him
Yeah.
that she shows up to this hearing.
I wonder who's watching her kids. Who's watching your kids, Lindsay? Who's watching your kids, Lindsay?
She's so scared of Turtle
I
Boy.
know.
Where are your kids, huh?
Yeah, they might be in Canton, right?
Wouldn't doubt it. Jen's probably watching them at the house.
Jesus Christ.
Tom's fucking hilarious. Who's watching your kids, Lindsay?
Yeah, Attorney Bradle couldn't get a word in edgewise.
What are you doing, guy?
Yeah, so
Well, I don't know.
I think he said 3:30 on the 17th, but it could have been 3.
I'm just in shock that even happened.
Yeah, and then so that means we don't have to go for Wednesday for Farwell. That got moved up. That was interesting. That got moved up to February 2025.
Wow.
And guess what date that is?
What?
Her anniversary.
No.
Yes, it is.
Wow.
That's fucked up.
Yeah, a lot. Wow.
Yeah,
I don't know.
like,
It's not, this whole thing. You couldn't make a movie out of this shit. It's a fucking
They would,
movie.
it's not believable, Mike. There's so many twists and turns. Can you imagine this being a movie and someone coming in halfway and saying, all right, catch me up to speed?
Yeah, no, it'll take you 6 hours.
Oh, no.
Oh, the kids are back in school. Are all her even closet babies? I don't know.
I can't really hear you, Mike.
All right, I'll let you. When they come out, I'm just gonna go quiet. Okay.
All right. I mean, it's gonna be interesting to see what they have to say.
I think Federer's pissed.
Yeah. Oh, I can't.
Oh, the
yeah.
suspense.
Yep.
I think he's pissed.
Oh, the suspense.
He's actually witnessing corruption in Massachusetts happen right in front of his eyes.
Closet baby watching Big Victims Kids, y'all.
Yeah. Let's go, Karen.
I do.
Loser. You're a fucking loser, guy. You're a fucking loser, guy.
Yeah. I can only imagine what Bedro's gonna write next for another letter, right? What's gonna happen then, right?
I don't, man. It's crazy. He must be shaking his head when he's driving home, going, I can't believe this is happening. You know.
Yeah.
Every other, because he knows experience. He's written these before in New York. It's not like it's uncommon for him. And then he submits one in a Massachusetts court, and it's completely different. All right, I'll let you go. Oh, who's this?
Yeah. I'm gonna check on the door here. I'm gonna check on the door.
Checking the door.
Man.
Get off my back.
Fucking guy.
Fucking guy. Get him, Tom. Let him know, Tom. We got your back, Tom.
What a morning, man. What the fuck?
Door works.
Still got a lot of people there.
Yeah. Good turnout. We're all waiting.
Coming right up.
Oh, the judge
here we go.
No doubt.
I think we got a
No
super
doubt.
bad, super bad.
Now,
I think we got a
if that's the
super
case,
bad,
right?
super bad, super bad, 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 bad,
He should be not even on the case. It's conflicted. He shouldn't even be here.
All right, so now they get a FOIA, right, and whatever, and they don't have an anonymous request, and the ADA doesn't, pick out what he wants to give. They get a real FOIA, or they get a real discovery, and they see Judge this O'Malley, Crop. It's fucking game over. That's what they're afraid of. This is nuts.
Yep.
It is. It's
But at least
fucking
we don't have to
insane,
wait
dude.
2-3 months. We got coming up on the 17th, and they're saying that hopefully Attorney Cosgrove and Federer and Bradle can work it out between them and try to figure out what they can get from each other. So that's what they're probably doing.
The only thing that would be like a viable thing, I would say, is drop all the charges and publicly give me an apology. That's what Aiden deserves.
Yeah.
Good morning,
But they won't give that. No way.
Okay, if it's not a fishing
What's illegal,
expedition,
guy?
and
Good
they've
morning,
had
or
it for a
fuck
year,
you.
You know they have stuff in there. You know what they saw, right? Because if there was nothing in there, they would have given it right back and taken what they wanted. But they know, either on purpose, they want to just piss them off and just get around it, you know, whatever.
Does DA still
But
have
who
access
knows?
to
They found
Turtleboy
something.
current email
They
through
know.
iCloud? Was he allowed to change iCloud password? Oh, that's a good question. I don't know. That's
Mike,
interesting. I don't know.
why is
That's a great
Lindsay
question.
even here?
Thank you,
That's
JB.
what I want to know. Because she's on him, dude. She's on him. She is on him with the whole setup with Mello and Tully.
Totally, Mike. Totally.
It doesn't make sense.
Marie gifted
Well,
10
they
membership. My bad. Hold on.
Information in it. They
That's
gave
right.
Aiden her
right.
extraction that had
That's-
his information in it.
Thank you,
That's
Marie.
That had his extraction in it too.
All
They
right.
gave it to Aiden. They screwed up. Because at the time they were telling Aiden's attorneys, we haven't touched it, it's in pristine condition. We haven't touched it, we haven't looked at it. And technically, I guess it's true. They didn't touch it. They didn't modify it. It's in pristine condition. It's as it was. But they have a copy of it and they were able to access it.
Thank you, Cindy.
That's
Camp.
the issue.
FYI, Lindsay Gattani's uncle is a Dedham police lieutenant. That may be how she always has.
But
an escort. I know her family.
I don't
Oh,
understand
Thank you, Cindy.
why Lindsay would be there if it's got to do with them
know.
asking for email, right? They wanted the emails from Morrissey.
Why was she there? Was she actually? I guess my question is, was she in the courtroom?
Oh, no.
So she wasn't even in the courtroom. She was just in court. I'll let you go. You have this one. Good.
The guy.
All right, there he is.
I
got my phone. It's only been a year.
I don't think it works.
He got his phone back.
No church.
He got his
It's a
phone.
step in the right direction. So,
That's a shop which I've never seen you look.
I don't know if that's a compliment.
That is a compliment.
Wow. Got your phone back.
Yeah,
How's it
so-
feel?
Feels good. I like. There's a lot of information on here, like we said, that we need to provide a defense. Like accusations they're making against us, I can refute things they're saying by going through old messages, stuff like that. So I need to be able to dig through this, and I've been trying to get it back for about 14 months now, and we finally got it. So we're good.
Are we gonna write the judge a letter, do you think?
Today's not the day to talk about letters. Got his phones. We're gonna get the text messages, emails, other things. So it's a long haul.
Tim, how frustrating was it to get up there in front of the judge and argue that to like deaf ears, it seemed like?
Yeah. So, a lot of you guys are veterans of this,
right.
this courthouse, this case. Remember when we came here for the bail revocation and the bail review? Judge Krupp likes to put us through the paces, but he usually gives us what we want. And that's what happened today. He put me through the paces. Absolutely. I had to eat my Wheaties this morning. Glad I did. And, he likes to do it. He wants to challenge you, and that's okay. That's what judges do, and that's what lawyers say back. So, he put us through the ringer, but we ended up walking out of here with his phone. And I don't think we would have unless we were putting the pressure on, and we've been putting the pressure on all this time. And how about getting this guy in here, getting the closer in here, to have Mark on the team has been such a pleasure, to take some of the heat off of me and push it that way. But it's been great having Mark, and we welcome him to this team, and it's a great addition. And we're not gonna give up. We're gonna keep going, and Aiden's gonna keep talking the talk, and he's gonna keep defending himself, and we're gonna keep defending him, and we're not gonna let up. And these are smaller battles in a bigger war that we're gonna win.
I love it.
And the next step on the 17th is
get in there,
get the
Scott.
trial date, get the stuff across the street in Dedham District, and I think we're gonna be okay.
So 17th.
Hell yeah.
Be back on the
Come
17th.
and
We have
get us.
Here, there 2 o'clock, and here 3 o'clock. So, all right. Busy.
Yep.
The
Thank
court
you,
across the
everybody.
street.
Thank you guys for coming. I love you guys.
Bundle up.
Thank you.
Back to work, Aiden. Now you're back to work.
Like you had two prosecutors in the room.
Yeah, here we put us through the case.
Amazing. So bittersweet. At least they got Turtleboy's phone back. That's fantastic. It's been 14 months.
You did that.
But they're the judge. Gotta play the
I
audience.
noticed he wasn't the same because.
But some.
Oh.
Yeah.
Thank you.
Good job, Tim. Thanks.
Tim Bradle's so cool, man.
Bye, Dina. Thank you for everything, sweetheart. Be good.
Is my boy, my husband, Blair around there tonight?
No,
He's not screaming?
Okay, I gotta mute Dina. Brad Blankenship, thank you. Wonder if this was the judge throwing a bone because he ain't giving up the emails. I mean, it's what it seems like. It seems like a bone being thrown there. That's what it seems like, and it feels that way for the right reasons. You know, it feels that way. It feels justified because of look at how long this shit has been going on. Like, forgive me if I don't give any of these court officials, except for Turtleboy's defense team, the benefit of the doubt here. Forgive me if I fail to do so, because they've been dicking this guy around for a year and 2 months. Right. Absolutely, just to pacify him is what it feels like. But at least he got it back. I'm grateful that they gave his phone back. So that, as Turtleboy stated, is a step in the right direction. But you know, it feels a little patronizing to me.
Hey, I can't add him. Oh, there you are. I couldn't add him. Won't let me. Hey, what's up, big guy? Good to see you. How have you been? What do you think about Helena and the kids?
Piece of shit.
And they doing honest to do nothing about it, right?
God, I'm the guy.
You're the guy.
A nigga. I'm gonna be shot in the head.
That they tried to kill you. I remember that. Yeah.
And they destroyed Jennifer's property right next to the Ken police. I'm waiting to see how much.
Oh, I remember this guy.
For these new kids who did that.
There won't be any charges. That's what's going to happen. I'll go in front of the magistrate. The magistrate's going to say, get out of here.
Yeah, but Trump is coming.
I remember
this
guy.
He is. He's going to knock some heads in, we hope.
Trump is coming. I want him to go after the governor.
The governor. Yeah, he's ultimately responsible, right? I agree with you.
I showed the evidence how they want to kill me, call me a nigger in the town. Basically, she told me to go and pound sand.
Christ, man. Come on, dude.
That's the record. Wow. But there is a God.
We don't like that word here.
Well, listen, you're not doing anything wrong. So that's the thing. You know, that's on them, right?
And I make money for them.
Yeah, imagine that. Wow. Well, keep doing the right thing. The right thing will happen, right?
I'm a Christian.
Yeah, you know.
I was born on 316.
You trust God. You know that.
That's right.
You know that. Yeah.
I'm back.
Woo.
Thanks for Turtleboy, man.
Yeah, thanks to Turtleboy. Think of all the things, the good stuff that he does. Right?
That's a real American. That's the image of an American.
Yeah.
A real American.
Stand up for what's right. Yeah, sidebar. What was the sidebar about?
I don't know. We need to find out.
All right, I'm not talking.
Yeah, my friend. I'll see ya. Be good. Yeah, take care.
Ask if you can find somebody. See if Lindsay was in the courthouse.
In the courtroom.
She was.
She was in the
She was
courtroom.
in the courthouse. Okay.
No, she was in the prosecutor's office.
She was in the prosecutor's office. Wow. So she was
I
sitting.
mean, it was
in
her
the prosecutor's
extraction.
office.
So I don't know why they would ask her.
That's fucked up. Fucked up.
Yep.
And I do like that guy from Canton there that's getting the run around with the bullshit.
Oh God, he's Mr. Travante, I think, right?
Yeah,
Salvador Travante.
He goes to all the standouts. He goes all the meetings.
Mike,
Yeah.
they threatened to kill the guy.
They
I
threatened
know.
to fucking kill him, dude.
Like that's no joke.
And so they're gonna put a.
I fucking love Tom's car, dude. I got to ride in it. It's a fucking classic, dude. Like, I'm nostalgic as fuck, man. Tom's got that cool fucking car. I never see those cars anymore.
I know. LG was there to intimidate, huh? You think? I don't know.
No.
No.
It was her extraction. That's why I think she was there, guys.
But they got eight.
Yeah,
phones
totally.
back today, though, too, which is.
Aiden got his phone back today.
Right.
That's a win. No matter what happens, that's a win. Right?
It is a win.
That's what we needed. Yep. So on the 17th, it sounded like he's got one across the street at 2:00.
Yes.
And then 3:00 across the other side of the street, right?
All right,
Is that
give
what
me
I
a
heard?
second here, folks. Well, that's interesting. Let's see real quick. Sorry, I'm looking for something here. Just give me a second. Okay, here we go. No, fuck off. Hold on, here we go.
Subordinate combing through his email that we lack confidence in.
This is only 45 seconds, so let me start it over.
This can be handled as a Rule 14.
Yes.
Oh no, this is live.
No
Sorry.
different than any other Rule 14 request to a prosecutor.
If it prefers the court, I will certainly jump to the Rule 14 component of this.
And what is it that you would be making the request for under Rule 14, and why should I consider it before you've made the request? I mean, a Rule 14 is a discovery request. You say, we want X, Y, or Z. Have you made a Rule 14 request?
Many, Your Honor.
And where will I find those? And do we have a motion to compel the Commonwealth to produce certain discovery that was requested under Rule 14?
Judge, they are referenced in the letters that were sent to Mr. Cosgrove, to which we have received in his response papers some degree of a response and that he agrees to provide us with text messages.
Okay.
So I believe.
All right, we need a break. We'll get you back into more of this motion hearing for Aiden Carney. I just thought it was Carney, but it's Carney. Turtleboy, you can call him if you want. He, of course, is facing witness intimidation charges connected to the case against Karen Reed. We'll get a break, get you back for more after this.
Tonight on Court TV.
I'm Vinny Politan. Welcome to Closing Arguments. We have a big hour ahead here.
Your deplorable actions are unforgivable.
The community still doesn't know how this Boston police officer died.
He can't prove one element of his case. It was a dramatic day, a dramatic moment inside the courtroom.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
I have a structured settlement and I call
J.G. Whitworth.
877 cash now.
I have an annuity, but I need cash now.
Call J.G. Whitworth. 877 cash now.
It's your money. Use it when you need it.
Call J.G. Whitworth. 877.
Call 877 Cash now to get a $100 gift card. For
Call 877 Cash now. Give me my money, JG Wentworth, right now. Wow. So Court TV had video this whole time. I guess they're going to continue with it. And this is on live Court TV. Like, it's live. So this is actually a good thing. Because anybody who's watching the Karen Reed case closely and they're following this on Court TV, they're gonna see, and if they're so inclined to do a little background, then they'll be able to put together how dirty and disgusting this shit is. Yeah, Bettero is outstanding. Absolutely fantastic. I mean, like I said, man, it was Superman versus Doomsday, man. That was crazy. This dude was doing everything he could to just block everything. And you saw how cool Bradle was. He's just like, he was just leaning up against the railing, talking to Tom, like it ain't nothing but a thing, like ain't nothing but a thing, Tom. We got his phone back. We'll be back in there. Bro, what is up with these commercials, dude? The Gene Autry show. What? Clubber's getting no, go lie down. You're lucky I caught that. You would have been in a lot more trouble had I not caught that. He got a hold of his wet food envelopes that, like, I have them shipped from by Amazon. And he's smart. He thought if he can get in them while I'm distracted, he could just tear them all up. Not today. Yeah, nice try, homie. Oh, and then he wants to come up here and be like all sweet. That's what he wants to do. Yeah, nice try, homie. Nope. But you'll get treats. You'll get treats when we go upstairs. I promise. Go lie down, bro. All right, here we go.
We got the suitcase murder sentencing coming up later this afternoon. We have that case out of South Carolina, the heartbreaker, the bride that was hit by the drunk driver. That case starting, but right now we are in Dedham, Massachusetts, and we're watching this motion hearing for the guy known as Turtleboy, Aiden Carney. He is accused of
the guy known as
intimidation
Turtleboy
prior to the high-profile murder trial for Karen Reed. Let's go back into the Massachusetts courtroom and pick it up where we left off.
Certainly Mr. Cosgrove is aware of our demand.
But I am not. You're asking me to compel Rule 14 discovery, and I don't have the requests submitted to me.
They were made in August of 2024, Your Honor.
And that was a follow-up request.
So
There was a May 8th discovery deadline.
but I don't have those. We're gonna go back to those discovery motions and revisit those now? You prepared to argue those now? I mean, I'm prepared to have you talk about discovery issues, see if you can resolve them, and if there's anything that the court needs to resolve with respect to emails from the district attorney or any subordinate of his, or other kinds of discovery that there's a dispute about, I'm happy to hear you. But it seems to me in the first instance, you folks ought to talk about it and see if you can resolve it. Does that make sense?
That does make sense.
Okay. All right. Are there any other motions that I need to deal with?
Not from the defense, Your Honor.
Okay. Let me just wait for a second. what is the status of the request for the taint team and how that will proceed with respect to the other devices if the motion to suppress is denied?
Your Honor, counsel filed the revised taint team proposal the last couple of days. We haven't had a chance to go over it or address it. And we would just object to any, for the record, on that point, we object to any further searches. We object to, the idea of providing us with this stuff here in open court on December 2nd.
All right, here's what I'm going to do. I'm going to see you before Christmas.
I'm going to get pissed off all over again.
We're going to talk about the protocols, how it will work. I'm going to get you a decision on the motion to suppress. And if there is going to be further searches, we're going to have to deal with that at a hearing before Christmas so that the case is moving along. You have now the disclosures of the contents of the extraction. And I can hear you on motion if you were ready for that, okay, things that you feel like should be suppressed. But I think that's pretty quick for you to pull that kind of thing together. But at a minimum, you folks ought to be in a position to figure out a taint team protocol for review of other devices if they're going to be searched. And you should also discuss any outstanding discovery disputes that I need to deal with. Let's talk about a time when you folks can be back.
I'm happy to do that, Your Honor. There is another motion that I filed that I'm fair on.
Sure.
Judge, I'm suggesting that we have a hearing across the street in Denver District Court on the Tuesday the 17th.
What time is that?
That's a 2 o'clock hearing. Judge, I'm here in this building at 9 o'clock for a motion to suppress with Judge Canoni. Could we maybe suggest, I'm trying to do my best. I court every single day up until Christmas, until I leave for Christmas holiday. But perhaps if I suggest December 17th, we're all sort of in the neighborhood, maybe an 11 o'clock call here. Would that be all right?
How about 3:30?
That's fine. That's fine with me, Your Honor.
Just give me a moment.
Yeah, sure.
Just so you know, I'm here at 9, motion to suppress across the street at 2 for Rule 17 in District Court matter.
And lunch down the street.
December 17th is fine, Your Honor.
Okay, yes, 3:30. We have a long list, I know, on the 17th, and I'm supposed to panel the jury in the morning. So I don't expect to be able to fit you in the morning. We're clear in the afternoon? Oh, perfect. Okay, so let's say 3 o'clock. So you can finish your 2 o'clock and come across the street and we'll deal with this. I don't expect it's going to be a long hearing because I think most of these things are going to work out, but, all right.
Thank you.
I mean, that's a plus right there where he says, well, I think that most of these things are going to work out. Okay, cool. Fine. I'll take that.
And again, if I could just.
Sure.
But I'm sick of okay, next hearing,
Okay, they're gonna do
something should happen.
Add a sidebar, and then I'll be back later this month on the 17th. Let's talk about this with trial attorney Nicole Brenecki. Nicole, this is not a case we would cover on Court TV if it weren't for Karen Reed and the insanity that that case has brought. And this is an extension of it. Would the Commonwealth be as aggressive in a witness intimidation case if it wasn't Karen Reed? Is this a sort of, is this part of the entire dig your heels in for whatever reason in this area of the country, or is this just something that we're picking up because of it and it happens?
I'm just going to call this guy not Julie Grant.
That's why we have this discovery dispute that's being discussed right now in a very heated manner, because all of it seems very controversial, and all of it seems like it needs more facts and clarification. In her case resulted in a mistrial, as we know. His case, however, there's voices being raised everywhere that the prosecution has failed at finding a connection between the alleged witness intimidation and her as a defendant in her own trial.
Exactly.
So, and now we have allegations of the DA potentially meddling with some communications which were not disclosed, some discovery that was not disclosed, and I think it all just adds to the controversy. However we interpret this based on the information that we have right now, it may change once these discovery violations are rectified and more information comes to surface.
And it does sound, at least at the end of the hearing here, that both sides agree that they can work some stuff out, and they'll be back on the 17th, and we'll continue to monitor it as sort of the Reed number 2 case. That's a little bit interesting.
The Reed
I don't think
number 2
anybody's digging
case.
their
Listen to this
heels in,
asshole.
For Turtleboy, like they do Karen Reed, but hey, here we are, and we'll watch it. Let's get a break here. We'll come back though, and head to California for a
Yeah, I don't know.
We're going to preview it in the celebrity stylist murder trial.
All right, go fuck yourself. Go fuck yourself, guy. Good morning, or fuck you. Yeah, this dude is like, how do I justify this? I don't know. I mean, we're showing it, but we don't ever show this. And how do I segue into making Turtleboy relevant when we've been trying to make him irrelevant this whole fucking time? We've been doing everything we can. No, bro. Like, we've been here. We've been here this whole fucking time, dude. I've been trying to tell you. How many months, people? How many months? Okay? How many months have I said the words, you cannot properly tell the Karen Reed, John O'Keefe story without telling the Turtleboy story? It cannot be done. It is absolutely relevant, and it is vital because the cases tie together. Absolutely 100%. The irony here is that Turtleboy was investigating as an independent journalist, investigating the Karen Reed case and uncovering all kinds of shit wrong with it. And seemingly the Commonwealth got scared, panicked, charged them with a bunch of trumped up bullshit. And then it turns out through Turtleboy's prosecution that they were able to discover that the corruption that was taking place, that he was trying to uncover in the Karen Reed case, is being applied in his case. And so now, we just got to wait. We just got to wait. Because now we have to go through the motions to get to this evidence, because an evidentiary hearing has not even been set yet. So now they're just trying to get through all the red tape to get an evidentiary hearing, where they could present this evidence and prove the corruption in Turtleboy's prosecution, which will inevitably prove, or at least served as exculpatory evidence in Karen Reed's case, ultimately. And this is the work, make no mistake, of both Timothy Bradel, but of the letters from Betterow. Letteros from Betterow. I love that handle, by the way. There's somebody named that. But yeah, this is I'm not defending Court TV in the slightest bit. I'm honestly not defending Court TV in the slightest bit. But this case, and thanks to Mark Betterow, this case is getting spicy. And so Court TV thinks that it's newsworthy now. Well, thank you, Court TV. Maybe other mainstream media sources will follow suit. But thank you for finally actually, you know, kind of giving in here when trying to fight the idea that Turtleboy's case is tied in with Karen Reed's. It's inevitable. It is. It just is. MCAT, yes, it is frustrating. It is frustrating. But sometimes it's fun. Which reminds me, I don't have a response yet, but it looks like this is still in its conceptual phases, so this is not final yet, but we've got a part 2 of Hannibal and Monty being guests on this channel again. In the works. It's in the works right now. So if you enjoyed it last time, make sure to be here for that part 2, because we're going to get into a lot more of the a lot more McAlbert stuff. So I'm really excited about that, because those guys are pretty invested now. And I had the best time hanging out with them. And every time I get to hang out with them, I have a great time. But that was the first time that they've been on this channel, and so hopefully we get to do that more. But I've been on their channel a couple of times, and it's always a blast. So yeah. I am gonna go live a little later today. I think I'm gonna try to anyway. If I could squeeze in the gym and another live, I will. Because I'm sure Turtleboy's going to go live at some point tonight to discuss everything, or he might wait till tomorrow. Who knows? Because there's usually the lives that he does on Tuesday nights at 9 p.m. But yeah. Oh, I totally agree, Scott. I mean, but the point here is exposure. Okay. There's more exposure on this, and I'll take it. It's fine. So I'm glad that Court TV live streamed this. I'm glad that they did that. So anybody who's sitting there in front of their TV and watching that is going, wait, what? What's going on here? So, and I thought that attorney was actually pretty knowledgeable. Usually there's some clueless fucker that didn't do any homework at all, but that attorney that he had to discuss the case was she seemed pretty knowledgeable, so I'm grateful for that. But guys, I am gonna wrap this up. Yeah, as soon as I say that, Kleber stretches. He's like ready to go. I am going to wrap this up. You guys are absolutely fantastic. Make sure, if you guys caught everything here, make sure to go over to Melanie Little's chat, give her a like. Make sure to go over. Make sure. I know most of you already did, but make sure to give Seeking Justice with Tom and Mike a like for being boots on the ground as they always are. They're invaluable what they do. So please make sure to show them some appreciation in any way that you can. And speaking of which, make sure if you are feeling generous and you see the shit that the delays, every time there's a delay, this is going to cost Turtleboy more and more and more money. And he is clearly being railroaded, as is Karen Reed. So the donation link for his defense fund, if you want to keep the killer bees having Turtleboy's back, then click on that link and give what you can. Even the smallest amount is appreciated, and it's very helpful. But anyways, guys, thank you guys for subscribing to this channel. Thank you guys for hitting the like. Please hit the like. I love hanging out with you guys. I always have the best time. And if, like I said, if I can, I will go live again this evening. Thank you guys for all of the support. You guys are incredibly, incredibly generous, and I can never express how grateful I am to you guys. And hopefully soon I'll be able to make another trip back to Boston to attend more of these hearings, because I am personally invested in all of this at this point. I have interacted with the locals there. They have welcomed me, and I can never express how grateful I am to that. The Reed family has embraced me. Turtleboy and Meredith have always been so hospitable to me. Every time I come up there, they always call me up and invite me out to a meal of food. And it's always great every single time. They're so kind. So everyone there, Boston is definitely a part of my heart now. And so I will do everything I can to go out there as often as I can from this point forward. So I really appreciate all you guys. You guys are amazing. I love you guys very much. And we will do this again very soon, my friends.